Morning, everybody. My name is Shrees. I'm the owner of the law office Shrees PC. I have here today with me Brian Block, and I'm going to talk about him in a minute. The name of the podcast is Lawyer Up Shrees Podcast, where we talk about issues that clients face in Virginia, Maryland, New York, New Jersey, and DC. Brian Block is a former Virginia State Trooper, and he's also a defense attorney for the firm. Today, we're going to talk to you about the topic of reckless driving. It's a very serious offense. It is an offense that is a class 1 misdemeanor in Virginia, and we're going to talk more about that. It can severely impact your life, and if you don't take it seriously, it might be the type of situation where you can land in jail for that. So having said that, Brian, thank you for joining me. Tell us a little bit about your background, Brian.
I was a state trooper for about 15 years, did a lot of work on the highway. I trained other troopers on radar. I arrested a lot of people for reckless driving and DUI, and now I'm working the other side of the fence, trying to help people get out of trouble that they get themselves into.
Now, Brian, you've primarily focused your practice on DUI, traffic offenses, and criminal cases, correct? Okay, and how long have you been an attorney, Brian?
About 18.
So you bring a substantial amount of experience above and beyond your background as a former state trooper. And how many reckless driving cases do you think you've handled so far, Brian?
After the first 2,000.
Wow, that's a lot. Brian, let's talk about the most common type of reckless driving offense, which is reckless driving under the code section 46.2-862, which is what is the 20 miles per hour over the speed limit or any speed over 85 miles an hour. So let's tell the viewers what that's about.
These charges are placed by officers using radar or a laser device, or sometimes just pacing the suspect vehicle, which means they'll get up behind the suspect vehicle and do a speedometer comparison. Now, sometimes this can only be an approximation of the speed. However, the proper way to do it is to get behind the vehicle or beside the vehicle and verify that the vehicle is going slightly faster than the police car, and then record the speedometer reading of that police car as the offense designation, which means you're allowing the suspect or the defendant probably a few miles per hour. So if you're charging them with 100 miles per hour by pace, probably you're doing 102, 103 miles per hour. The radar is accurate to well more than 1/100th of a mile per hour, and the laser is accurate to even more of a degree. So these are very precise measurements. So these people are pulled over and they're issued what they think is a speeding ticket, but it's charged as reckless driving under Virginia Code 46.2-862 if they are doing more than 20 miles per hour over the speed limit or more than 85 miles per hour if the speed limit is 70 miles per hour or more. This is a class 1 misdemeanor, and it also is a very serious offense according to insurance companies, which will sometimes cancel somebody's insurance or raise their rates substantially.
Okay. Just so the viewers can understand my background as well, in addition to being the owner, I used to be a former prosecutor in Virginia, and I used to see a lot of these cases, and I prosecuted a lot of these cases, and I guess I have probably prosecuted well over 2,000. Reckless driving is just not based on speedometer, right? There are a host of other offenses that would qualify as reckless driving, correct?
And the other code section that's most commonly used is 46.2-862, which, if I can read it in its entirety, it's very short. It says, irrespective of the maximum speed permitted by law, any person who drives a vehicle on any highway recklessly or at a speed or any manner so as to endanger life, limb, or property of any person shall be guilty of reckless driving. So this code section is very short, but it's very broad, and it's subject to interpretation.
And I guess from a prosecutor's standpoint, manner so as to endanger, that's pretty much anything they think would endanger life, limb, or property. I mean, it could be even going under the speed limit, but because the weather conditions are not appropriate, you could get charged with it. It's kind of like a catch-all exception, isn't it? The reckless driving.
It is. In order to defend somebody against a charge of reckless driving, very often we have to research the case law to see where judges have decided whether the evidence is sufficient to convict somebody of reckless driving, or whether this charge should be reduced to improper driving, which is a minor traffic offense, or if the charge should be dismissed. So many times people are charged with reckless driving as a result of a traffic accident, where a police officer investigating this accident will somehow infer that the person, the driver, operated his vehicle in a reckless manner and endangered life, limb, or property, when in fact the accident may not have been the fault of the driver, or the driver could be only guilty of some minor traffic offense which resulted in an accident.
There are so many different things that are deemed reckless driving. For example, aggressive driving. What else is deemed reckless driving by the courts, by the law?
Various things. There are improper passing, which is extremely close and causes other people to be placed in danger. There's reckless driving on private property. There are a host of other code sections that involve reckless driving. However, the gravamen of the offense, or the core of the offense, has to be that someone was reckless, which in legal terms means a conscious disregard of a substantial risk to other people or their property. This is more than negligence. It has to be somebody that just breaks all the rules and just doesn't care and shows that he doesn't care about someone else's life or their property and operates his vehicle in such a manner as to place them in danger, and that he does so without regard for the rights of these other people. So here we get into a discussion sometimes in court of whether or not this is a simple negligence issue or if it rises to recklessness according to the legal definition, and that this person could be convicted of actual reckless driving, which is a criminal offense in Virginia.
So if there's driving too fast for conditions, I used to see that a lot when I was a prosecutor. It could be poor visibility, a pedestrian is present, the roads are wet. Any of those can easily get you charged with reckless driving. Would you agree with that?
It could get you charged, but it's often not enough to get you convicted if your case is properly defended. Sometimes officers investigating a traffic accident in bad weather will simply infer that the driver was going too fast for the weather conditions or for the road conditions, meaning snow or ice or something in that manner, and that was the cause of the accident, and therefore charged the person with reckless driving. However, when we defend these cases in court, we can often get them dismissed because the officer cannot prove how fast they were actually going, and we can challenge this simple inference under the case law enunciated by Powers versus Commonwealth and show that this kind of inference is not permissible and get these charges dismissed.
Now let's talk about the fact that this is a class 1 misdemeanor, right?
Correct.
And there is some substantial penalties behind being convicted of a class 1 misdemeanor. Would you agree with that?
I agree. According to the law, if you are convicted of reckless driving, either by speed or reckless driving in general, or any of the other reckless driving code sections, you can be subjected to up to 1 year in jail, $2,500 fine, and having your license suspended for as much as 6 months. And then there's the insurance problems. Insurance companies do not like these reckless driving convictions, and we often have clients that are put in danger of having their insurance canceled or having their insurance rates doubled as a result of a reckless driving conviction.
Right. Tell the viewers what are some of the different class 1 misdemeanors in Virginia, so it helps them understand how seriously Virginia considers a class 1 misdemeanor, reckless driving offense.
Okay. Other class 1 misdemeanors are such things as DUI. That's a traffic offense, but it's in the, they actually place it in the criminal code section under Title 18.2 instead of the traffic offense code section, which is 46.2. So it's DUI is another class 1 misdemeanor. Also assault and battery, trespassing, and other rather serious offenses. Anything that's less than a felony is a misdemeanor, and a class 1 misdemeanor is the highest level of misdemeanor before the law puts it in the felony category.
The thing that blows my mind, and I remember to this day when I first started practicing in Virginia, reckless driving is a class 1 misdemeanor, and it's as serious as a charge of domestic violence. That's what blows my mind, and I think a lot of people, as a defense attorney and a former prosecutor, and especially as a former prosecutor, I used to deal with people who didn't have an attorney, and they didn't even know how serious the offense was. And so often they'd be like, well, okay, if I'm not getting jail time, I'm just paying a fine, which is a viable option in a reckless driving case. What's the big deal? It's only down the road they realize, oh my God, this is going to mess up my job potentially. It could have a significant impact on your security clearance. And based on the current situation with immigration, it can result in immigration consequences. This is some serious penalties that are collateral to just the potential for jail time and a fine and a criminal record. And how often do you run into clients who are just baffled by the seriousness of this?
We have clients sometimes who have defaulted on their summons, meaning they didn't come to court, they were convicted in their absence, they may have only been levied a fine, but then they get a notice from their home state that their license has been suspended. They get some notice from their insurance company that their insurance has been canceled, and they have problems with their employer. And then they come to us, and we'll try to get the case reopened, or if it's within the time limit, get the case appealed to circuit court and try to retry the case. And sometimes we're successful in getting the charge dismissed or getting it reduced to some lesser offense like simple speeding or improper driving, which once again is a minor traffic offense, and saving the client from some very serious consequences. So it's best if the client understands how serious this is from the beginning and retains a competent lawyer who can properly defend them in the first instance, because the time for appeal from a general district court conviction is only 10 days. If that is expired, we have 60 days to reopen the case or to apply to get the case reopened. If it's after 60 days, the client could be stuck with a reckless driving conviction and some very serious consequences.
So let's talk about this, just so that everybody understands this. You get convicted of reckless driving, you got a class 1 misdemeanor on your record for the rest of your life, right? That's problem number 1. 2, if you're convicted, you can't get it expunged. 3, there's a serious potential for jail time if there are aggravating factors. Let's not kid ourselves. You and I have both seen this from the perspective of lawyers who shall go unnamed routinely try to scare clients into believing, oh, you're going to go to jail on a reckless driving. That's really, unless there are certain aggravating factors, you agree that's not a realistic possibility, correct? Okay. Now, what factors does increase the likelihood of going to jail?
Those factors would be actually injuring someone, or if you're charged with going more than 30 miles per hour over the speed limit, jail time could be a real possibility. Some judges do not like those triple digits. If you're charged with doing more than 100 miles per hour, you could be facing jail time. Sometimes clients are arraigned on these charges, which means the judge brings them to court and verifies that they understand that they have a right to representation by an attorney because it's a jailable offense. And if they cannot afford to hire an attorney, they offer to appoint an attorney for them or refer them to the public defender. So those are jailable. Accidents involving serious injury are jailable. And then,
what about a poor driving record?
You got a bad driving record, the judge is likely not to cut you a lot of slack if you are convicted, or if he finds that there's evidence to convict you of one of these serious offenses. So someone who has been charged with doing maybe 100 miles per hour, if they have a perfect driving record, we can often avoid jail time, even though another person charged with that same offense who has a poor driving record will have worn out the patience of the court, and the judge will simply decide that they need to be taught a lesson with a day or two in jail.
Now, in addition to the maximum fine of $2,500, the jail time, the conviction on your record, you get how many points for this offense?
6 points.
Okay. And it means it's going to stay on your driving record for 11 years, correct?
The offense stays on the record for 11 years. The point system in Virginia only records those points for 2 years, and then you start over again. The threshold for getting in trouble with Virginia DMV is 12 points. So 2 reckless driving convictions at 6 points apiece could put you over that 12-point threshold, and you could be in danger of getting your license suspended by Virginia DMV. Now, each state has its own point system, and how those points are recorded and how long those points stay on a driving record depends on which state you have your license issued by.
For example, let's talk about that because that's something we deal with a lot in terms of out-of-state drivers. Out-of-state drivers, especially from North Carolina, a lot of them don't realize that even if they're caught going 16 miles on the speed limit, that their license in North Carolina can get suspended, correct?
That is correct. North Carolina has a law, a rule, that if someone is convicted for going more than 15 miles per hour over the speed limit, their license will be suspended for 30 days, even if it's an out-of-state conviction. So when we get a North Carolina client, we try to convince a prosecutor that this person is eligible for a break of some sort, and even if they're charged with a higher speed, get it reduced to 14 miles per hour or more, less than the speed limit, to save their North Carolina driver's license.
Before we get into how you defend these cases, Brian, because I know you are, we can't use the word expert in Virginia because that's not allowed by the Virginia State Bar, but you're damn close to one, in my opinion, based on your background. But before we get into the way you defend it, I kind of want to talk to you about, you've probably seen this, I've certainly seen it, when people don't realize when they go for security clearance or they're applying for immigration status that a reckless driving conviction can really mess them up. I mean, that is one collateral consequence. I'm not so sure whether all the lawyers talk to them about or talk to clients about it, but that's a very serious collateral consequence that most people don't even think about. And they certainly don't think about it in most instances if they don't have a lawyer. They just go, well, I'll just pay the fine and move on. Then the other component, of course, is, you and I have done this successfully numerous times. Of course, depending on the circumstances, it's not feasible. But even though the appearance is mandatory for reckless driving, we've been able to get the courts to waive it. And do you run into a lot of problems with that with your cases?
Are you talking about getting someone's court appearance waived because they live out of state or some distance very far away? Okay. Sometimes that requires a special motion before the court. So on these, to save someone from traveling all the way from California to Virginia to go to trial, we will have to make 2 or even 3 court appearances on their behalf to convince a judge that they should not be required to travel such a distance to come to court and to try them in their absence. Once we convince a judge that this is appropriate, then we can represent them in their absence, which means we're asking the judge to waive jail time. Because the reason people are required to come to court very often is because jail time is possible. And a judge doesn't want to have to go find somebody somewhere in the United States after he's already decided he's going to send them to jail. He wants them there, present in court, so that if he decides that they need to go to jail, he has a hold of them right away. So this is the problem we run into, convincing a prosecutor that jail time is really not appropriate in that case, and that the client should not have to come a significant distance from the West Coast, for instance, all the way to Virginia to stand trial when it's not likely that the judge will sentence him to jail anyway, and with some other penalty, such as requiring community service or some other sort of deferred disposition, may be more appropriate.
Yeah, my experience, and this is different because, Virginia each court has its own rhythm and kind of like unwritten rules. You've been in many, many courts throughout the Commonwealth. So have I, and I can tell you, my experience is with the judges, it could be that the person lives literally in the same county that they got the reckless driving ticket in, and if you take the necessary steps, and the case is one that would suggest to the court that jail time is not necessary in this case, you can get the appearance waived, but it is on a case by case basis because if it's an extreme speed case, they're probably not going to waive it. I mean, I have had cases where I've gone to court and I have gone to court without my client with the understanding with my client that I'm going to try and take care of this without them, and they've signed an authorization letter for me to represent them in their absence. But there's no guarantees, and I think it's something that clients need to understand that one, a lawyer can never guarantee an outcome, and two, a lawyer can try to waive their appearance. That's not guaranteed, and if the client has to appear, then that's an unfortunate reality that they have to live with. Now, Brian, in terms of defending these cases, take me through the different ways you would attack a case of reckless driving.
Depends on whether it's a reckless driving by speed or reckless driving according to some other allegation, such as the general rule of wanton and reckless operation of a motor vehicle. If it's a speed violation, very often we use the very technical defenses, challenging the officer's target acquisition and discrimination, challenging his proper calibration of his radar unit, or the LiDAR unit, going off the records, because the officer has to produce these in court if challenged to show that his equipment was in proper working order, properly calibrated, and that he knows how to use it, and that he did use the equipment in the proper manner. If it's a case of reckless driving according to the general rule of simple, wanton, and reckless operation of a motor vehicle, we often look at the case law, and that's because the code section is so broad. We need to look at case law where we can show Supreme Court decisions that said that the conduct alleged is not substantial enough to meet the requirements for a conviction, and simply challenging according to the law, bringing in a lot of case law, and showing the judge that this does not amount to reckless driving. Proper driving, possibly, but not reckless driving. And that's a big break if we get it reduced to improper driving, because this goes from a Class 1 misdemeanor with a potential of jail time and $2,500 fine, license suspension, down to a minor traffic offense for which the maximum penalty is only a $500 fine, no license suspension possible under that code section, and
Well, let me ask you
no
about
jail time.
let me ask you about this. As a defense attorney, what role do you see mitigation playing in this, in terms of things that a client can do to try and put themselves in a better light?
It's a double-edged sword. If we're telling a client that we think that they need to do some mitigation, we're telling the client that we've evaluated their case, and it is highly likely that if it goes to trial, they will be convicted of reckless driving or some other offense that is very serious. At this point, we are trying to give the judge some reason to show some leniency, because we're offering to show that the client has educated himself by a driver improvement course so that his driving behavior is corrected, or that he has done some community service in lieu of jail time, and we're asking the judge to accept that instead of sending the client to jail. Sometimes this works. Sometimes the judge will be not satisfied with what we've offered as mitigation and require more, or sometimes we'll send a client to jail anyway. So this is very difficult to navigate, and sometimes it requires knowing which judge you're dealing with, which can be very difficult in some courthouses where there are 5 or more judges sitting in 5 or more courtrooms each day, and we don't know which judge we're going to go in front of on any particular day.
Well, I can tell you, as a prosecutor, while it's our job to pursue the charges that are brought by the police officer, we had discretion as to do we go aggressively against the individual who has been charged with this offense, or in the alternative, whether we give them some kind of latitude. And I have always found, both as a prosecutor and as a defense attorney, that you could, when you're negotiating with the Commonwealth, and that's just before I go forward on that, clients have to understand that not every jurisdiction nowadays, especially nowadays, will have a Commonwealth attorney on a reckless driving case. A lot of times it's just you, your defense lawyer, if you have hired one, and the judge. Especially in those kind of situations, if you don't have an attorney, your chance of success of trying to avoid a reckless driving conviction dramatically decreases. So mitigation is definitely a relevant factor in my experience, because I have been able to successfully have clients complete a lot of community service. Because at the end of the day, the way I look at it is this. You're accused of having violated the law. If you could show remorse, you could show that you're trying to give back to society to repay or repent for your actions, then that tends to give you a lot of latitude. Now, moving along the lines of the value of, having an attorney who knows what they're doing, as opposed to situations where you and I have talked about it many times, these law firms that come in with 15, 20 cases because they've charged some ridiculously low fee. What's your thoughts on that?
I've seen lawyers spend very little time before the bench arguing these cases. They come in with 20 cases. They will often dispose of these cases in court in less than 1 minute for each case. And it's obvious to me that their preparation time has not been very substantial either. They've often just had a legal assistant get a little bit of information from the client, print it out, put it in their file, and then go to court, and their total time spent on a case may be less than 10 minutes. Typically, I will spend 2 or more hours on a routine reckless driving case. If it's a substantial case where we have a lot of evidence, the issue may be in doubt, I have spent 6, 7, or 10 hours preparing to defend a reckless driving case, especially if it's a serious offense, and I'm looking at case law, trying to show a judge that it does not amount to reckless driving, or perhaps not even improper driving, and this is what's necessary to get these cases dismissed. Now, of course, we can't do anything if the evidence is clear, and if the case law is clear that it amounts to reckless driving. We cannot guarantee that no matter how hard we work on a case, that we're going to get a case dismissed. Very often we don't know which judge we're going to go in front of or how the case will unfold, but we can give the client a fighting chance, I think, much more than a lawyer who only spends 2 or 3 minutes on a case until.
I can tell you when I was a prosecutor and I used to see some of these attorneys come by, they would literally have virtually no real knowledge of their client. Because part of what, at least my experience was, is that the lawyers who knew their clients could really advocate for them, could identify the flaws that perhaps the police officer or the trooper made, were able to better outcomes than the attorneys who just came in and had this mentality of let me just plead this out, get this case over with and move on. And I certainly, when I used to handle reckless driving cases, defense attorney, I would literally take in a binder which would have everything that could be possibly represented as something positive about my client. And those are things that, I know you and I both do it. We prepare those binders so that we can present a very comprehensive picture of our client, not just, oh, my client's a good client, so cut him a break. That doesn't really get you anything. I guess I would say in closing, who you have as your attorney on a reckless driving case can make a substantial difference. I say this over and over again. Lawyers are not fungible goods. They're not, you go to the grocery store and you see 2 heads of lettuce and you go, well, what's the difference between either of these 2 heads of lettuce? I'll just get whichever one is perhaps better priced. That's not how I think lawyers should be viewed by the public. I think when clients are looking for a lawyer, they really should be taking the time to figure out whether the lawyer has the knowledge and the experience to handle their case. And while there's no guarantees, I think you enhance your chance of success. Brian, thank you so much for taking the time to join me today. That concludes this session of our Lawyer Up Streets podcast. I hope the viewers who are viewing this or maybe hearing this have found some value from this. And thank you for your time, Brian.
Thank you for having me.
Have a great day, Brian.
Thank you.
Bye bye.